And for 4 generations, members of my family have tried to do their part to resolve Puerto Rico's status problem. I take some pride in the fact that we've represented essentially every point of view on the matter, and we still get along. So I'm very much looking forward to our discussion. Let me start by recalling President Obama's own words on this topic, which I'm sure you know. Soon after his election, the president wrote a letter to Governor-elect Luis Fortuño of Puerto Rico in which he made a promise to resolve the status problem by 2012. This time, he wrote, must be different. No previous president had ever made such a clear commitment to the people of Puerto Rico with respect to the status problem, a problem that has been unresolved for more than a century. It was a courageous thing to say, and it was the right thing to say. You all play a critical role in advising the president how to fulfill this pledge, and my aim today is to do what I can to assist you in your efforts. To this end, I'm going to use my time to raise and examine what I take to be the critical question at stake in these matters, which, beautifully, is the same question that Professor Pildes takes to be the critical question. So you expected disagreement, and you have so much consensus right now. The question that needs to be addressed, the question we need you to address, is can Puerto Rico and the United States form a permanent union, a union that will guarantee U.S. citizenship to the people of Puerto Rico without the admission of Puerto Rico into the Union as a state? Professor Pildes is right. That's the question. So over the next 12 minutes or so, I'm going to do 3 things. I'm going to talk about why this question is important, about what the answer is, and about what the president can do about it. So first, why is this question so important? Anyone who knows anything about Puerto Rico's status debate knows that Puerto Ricans disagree on the best way forward. We've got statehood, independence, free association, commonwealth, new commonwealth, enhanced commonwealth. There's a lot on the table. But what's essential to recognize is that there's important common ground on the island, which is easy to overlook in the heat of debates. But that common ground is there, and it goes directly to the heart of the question before us. Puerto Ricans overwhelmingly agree on this. We want permanent union with the United States, and we want guaranteed U.S. citizenship. Recent plebiscites may have been confusing, but they do establish what I've just said. Overwhelmingly, Puerto Ricans want permanent union and guaranteed citizenship, and by that I mean Puerto Ricans want a guarantee that Congress will not take away the citizenship of persons who've already acquired it by virtue of birth in Puerto Rico, as well as a guarantee that Congress will continue granting U.S. citizenship to Puerto Ricans, persons born in Puerto Rico, in the future. Supporters of statehood want this, and supporters of Commonwealth want this. And as you know, these 2 groups form the vast majority of the electorate, by which I don't mean 57.5%. I mean closer to 90%. I mean virtually everybody. What we're divided on, then, isn't what we want, it's how to get there. About half of us think statehood is the answer. About half of us think some version of Commonwealth is the way to get there. And here's where the Constitution comes in. That statehood, as you heard, would make Puerto Rico a permanent part of the United States is straightforward, constitutionally speaking. And under the 14th Amendment, persons born in the United States have birthright U.S. citizenship. Easy. Done. The question is about Commonwealth. Supporters of what has come to be known as new or enhanced Commonwealth will tell you, as you heard Professor Pildes say, that yes, Commonwealth can also mean permanent union with the United States and guaranteed U.S. citizenship. They will tell you that Puerto Rico can have a binding bilateral compact with the United States, unalterable except by mutual consent, and that as part of that compact, persons born in Puerto Rico can enjoy a guarantee of U.S. citizenship now and into the future. At the very same time, they will tell you that the compact would affirm Puerto Rico's separate nationality, and that under it, Puerto Rico retains sovereignty that it delegates as it sees fit. And they will tell you that Puerto Rico can have a host of additional powers, and we can talk about those in the Q&A if you'd like. So I hope you can see why this question is so important. if Puerto Rico can have permanent union and guaranteed U.S. citizenship without becoming a state, then we've got two options for getting what Puerto Ricans have repeatedly said they want: statehood or some version of Commonwealth. But if this can't be done, then Puerto Ricans only have one option: statehood. And what that means is that it is impossible for Puerto Ricans even to know what their options are, much less to choose one of them, without an answer to this critical constitutional question. So let me talk about the answer for a second. Proponents of new or enhanced Commonwealth will tell you that nothing in the Constitution prevents Congress from entering into the proposed compact. Therefore, Congress can do it. QED. All that takes, they argue, is creative statesmanship. That's what we need: creative statesmanship. The problem with this, what is known as the compact theory in its various forms, is that it reflects a fundamentally misguided understanding of the Constitution and of Congress's powers under it, and here we're going to see a little disagreement. And let me address the two central components in turn: permanent union and then guaranteed citizenship. As to permanent union, no one denies that Congress has the power to be creative in Puerto Rico. Congress has already been very creative in Puerto Rico. That's beside the point. The point is that whatever experiments Congress can undertake with respect to its largest territory, what Congress cannot do is bind the United States to a bilateral compact with a non-state entity, a compact that affirms each side's separate nationality, but from which neither party can withdraw without the other's permission. To suggest otherwise is to put aside the entire legal framework that governs national sovereignty, territorial boundaries, and self-determination itself. If conditions were someday to persuade a subsequent Congress, or the executive for that matter, that U.S. national interests required an end to said compact with Puerto Rico, the United States would be well within its rights as a sovereign nation to withdraw from the arrangement. Such determinations belong entirely to the political branches, and no court would stand in the way. The strongest arguments, let me just address a few of the points that my colleague made. The strongest argument against the compact isn't this truism that one Congress cannot bind another, because we know that one Congress, there are exceptions to this rule. 95% of the time it's true. There are some exceptions to the rule. The strongest argument is the legal framework that governs national sovereignty and self-determination. The precedents cited don't support the compact, and I'll just address a couple. The Rasmussen case did not talk about Congress promising incorporation by statute. In fact, Congress has never promised incorporation by statute. Incorporation involves a treaty, which then Congress may or may not try to override, but there are no instances of Congress promising incorporation by statute. Incorporation does exist, of course, but it is impossible to understand separate from statehood. It is the first step in a process that culminates in statehood, and I can talk about that more later.
We've been really focusing on looking towards the future and what kind of training we can provide that will match what these other departments are doing in terms of the ability to attract investment, so that we're training the workforce for the future in areas like green jobs, possibility for health care, allied health, etc. We toured along with everyone and received a lot of really interesting information from regional municipalities and municipalities, specifically around their interests, because we need to hear from you what you think, where the island can go, and what kind of investments can be made, and how we can also better leverage our resources as we move forward. So everything from infrastructure we heard, and as well as issues like tourism and ecotourism. So it's all looking forward.
Deny that. It's guaranteed not by the 14th Amendment, but by the Due Process Clause. The relevant case law makes clear that you cannot be stripped of your citizenship if you already have it, as long as there's no evidence of your intent to do so. But the difference, the crucial point here, is that the compact would promise citizenship going forward. The idea is that Congress would be bound forever, or as long as the compact lasted, to keep granting citizenship to Puerto Ricans in the future. Persons born in Puerto Rico, that is. And no Congress can make that promise, because Congress can always amend the statutes that govern citizenship. So no one should promise this to Puerto Ricans, because Congress doesn't have the power to make that promise. At this point, proponents of the compact will often point out that a majority of the people have already voted for some version of this status, and let me just say about that, that a version of this option has won in the past, that more recently it has lost its majority but retained a plurality, and that would be various versions of it cobbled together, may retain a plurality. But here's the thing. I believe in self-determination as much as anyone, but just because the people voted for something, the brutal truth is that doesn't make it constitutional. It is unfair to the voters to offer them an option that is not constitutionally viable precisely because they might vote for it. Allowing them to vote for something, for a promise that Congress can't keep, doesn't vindicate the values